nearly done, mate. We're nearly done. We might have got the same. They're only to go.
Sorry? I think it said 14. I was like, what?
Three more. Straight in and I'm done. Okay.
It was just this.
But it done. He's got it, the one that you attached anyway, with him on the All rise. Good morning, all. We're here today for day one of the hearing in the matter CFI 2, 2016, before Deputy Chief Justice Sir David Steele. The claimants represented by DLA Piper Middle East LLP. Lead counsel is David Thomas QC. The defendants represented by Allen and Overy LLP. Lead counsel is Christopher Mainwaring Taylor and Yassine Francis.
Yes. Hello. Lima. Sorry.
Yes.
Yes, let's get underway. Thank you. I was just saying that it's rather cold in here, I thought.
Indeed.
So I was asking for the air conditioning to be either turned off or at least reduced.
I'm
Sorry, let me just give me one moment. I saw. There we are. Yes, Mr. Thomas.
May it please your Lordship, I don't think there are any housekeeping issues. So perhaps we should just say that the parties have agreed that the witnesses on both sides may be present throughout the hearing. Are, I believe. But, my Lord, we also have an agreed outline of a timetable, and we don't think at the moment it's under threat in any way. Indeed, we should come in within it, I would hope. So that gives this afternoon for the two oral openings, and then we move on.
Thank you.
So in my allotted first half of the afternoon, I was proposing, if it assists your Lordship, and please stop me if I'm going too slowly, to run through the chronology via the documents in the bundle, drawing attention to those that I think will probably loom large in the history of this matter. If your Lordship's already familiar with the documents, if you've had a chance to read them, then please stop me and I'll speed along. But
I think you can assume, of course, that I've read the skeletons and glanced through the chronology. I've seen the statements, but that is the limit of my reading.
yes.
And even then, I'm not promising I remember what I've read, which is another problem.
Well, indeed, then I'll go through the history of the matter in outline,
Thank you.
and then I'll just deal with the issues as they now appear, as indeed I think they've been clarified to a degree by the two written openings. Some further clarification may be possible. I'll start then with just the events. You will have seen that the history of the matter really starts back in 2007 and 2008, when the claimant had permission to build a hotel and indeed residential facilities on the Palm. He secured a facility with the bank in 2008 to finance that project. That original facility is at bundle 5, page 41. The global financial crisis then...
So forgive me, the chronology is not, isn't cross-referred to the bundles?
No.
Well, my copy isn't. No, okay. No, I'm not complaining. I just want to make sure I got the right one, yes.
Yes. I mean, I'm really picking it up from our own opening and enlarging
Thank you.
On that, and just trying to focus a little more on perhaps what may be the important matters.
Yes.
That said, I'm on pure background now, just to get our bearings. That original project 2007-8, 2009 global financial crisis, and it comes to a halt. 2010 restart, but scaled back to just a 5-star hotel, so no residential facilities. And there was an amended loan facility put in place at that stage, which is at bundle 5, page 42, and that was a facility of 444 million dirhams. In May...
Sorry, let me just... You said the new facility is referred to in paragraph what of your skeleton?
That is in...
got the construction contract in May.
Yes.
The new facilities were...
that is in paragraph 9.
Sorry, give me the cross-reference again.
542.
Thank you. Yep.
And then you see the construction contract comes in on the 22nd of May.
Yep.
I don't think we need to go to that. And I've noted paragraph 11. Then really the works start, but they're delayed. Costs mount through 2010, 11, 12. By 2013, there's certainly problems, and in the first half of 2014, there's no drawdown permitted under the facility. So the facility stays in place, but no drawdown permitted. Now, paragraph 14 of my skeleton, I think, is not entirely accurate. There we refer to the appointment of E.C. Harris, but there's a two-stages to the retainer of E.C. Harris, and can I just straighten this out a little by looking at the document that we refer to there, which is at bundle 7, page 74.
Oh, I see now. I was trying to find where the numbering was. Yes, okay.
The numbering is quite small, I'm afraid,
Yes.
on the spines. I've resorted to large manuscript, but I'm sure we can get someone to do that.
I think what I might ask is somebody with a big pen could scrawl on these things, the bundle number would be, or letter would be. Right, so you want 774?
Yes, just I think just look at the executive summary. We can see what the commission is here on page 774, and because they record their instructions, they've been commissioned by the bank to undertake a due diligence report on the property known as Seaview Hotel, being developed by DAS Projects. The instructions and scope of the appointment are contained within the appointment document, but we don't have that, and they're briefly as follows. Take a commercial assessment of the project, provide an overview of completeness, highlight any existing potential areas of cost escalation or program extension, any key risks associated with the development. And they go down the page, you can see they give a summary. It's the second paragraph, it's a high-level review as of December 2013, and a high-level commercial overview that DAS's current forecast budget was 537 million, but their own estimated budget was 650 million. Over the page, on progress overview, they noted that the project was around 65% completed, but on-site productivity is at a very low ebb, only 220 workers, whereas we'd expect at least 600. The contractor was unable to produce a reasoned programme to completion. They note at the bottom of that page, we're informed there's no hotel operator involved or under a draft hotel management agreement. So that was the position at that stage, and that was the initial appointment.
The date of this is?
This is December 2013.
Yeah.
It's right to say that there is a revised version of it in January of 2014 at tab 79 of the bundle. The document begins at, yes, it says 79, tab 79, yeah. And if you 1441, you can see the same numbers there. There's a little bit being added to the summary. The third paragraph there's been added about the state of the project. I don't think the detail of those documents matter. But that is their first appointment, and indeed they produce another document, it seems, as an update to that. If we look in bundle 8, that another report that they produce in April 2014, and you can see that at tab 106, bundle 8. What's essentially happening is that the project's in some difficulty. The banks retained Harris to have a look at it, and they're reporting December, January, and then again, here we are in April, they report again.
Yeah.
And this is in fact an extract from the report they produce that the bank are sending to the claimant at this stage. And this is the 16th of April. There's in fact an updated one on the 28th of April, which is, I think, the one that really features in our story rather more. It's a revision and update at tab 108.
So I don't. Right.
I don't
so
think
we've got April. Well,
yes.
Some dates in April for 106. Now we're going to
108, which I think is matters.
Yeah.
And that you get the date of the 28th of April from the first page in the tab.
Yes.
And then you get the report itself. And you can see what this is from, if you look at page 1628, you can see the executive summary. It's an update to our previous report issued on the 19th of December under the commercial due diligence report. And then again, there's a high-level commercial overview lower down the page, where we can still see that there's Harris's estimate of the development budget is 650 million. DAS and HQS, they record, are at 665 million. HQS are the cost consultants retained on the project by DAS, the claimant. There are some other points that we should note about this document. There's a summary, findings and next steps on page 1629. The commercial assessment demonstrates that their anticipated spend is closer to our benchmark data, excluding applicable costs. They say there remains a significant quantum of claims from the contractor, which may yet be submitted. They refer to the state of the design, or design of external works and landscaping appears to be absent at that stage. And they make recommendations, or recommendations from the 19th of December still stand, and they want the appointment of a project manager, a design check, involving contractual and commercial arrangements with the main contractor. If we turn on the programme on page 1635, they say that they've been sent a revised programme prepared by Intermas, the main contractor, dated the 10th of April, and they make observations on that as follows. The programme overall records the outstanding work generally as we'd observed in December, confirming most significant items outstanding are the mechanical, electrical, plumbing works, second fix, internal finishes, and so on. And then the second bullet point, the overall timescale, indicates a revised date for completion of 20th of December 2014, plus commissioning. We estimate a further 12 weeks for this activity, equating to a final completion of the end of March 2015. This contrasts to our estimate, judged on the observed outstanding works of May 2015. Thus, we feel that the contractor's programme could be slightly optimistic, but not overly so. There's the evidence of the witnesses for the defendant is that date of March 2015, that this document, this report, is the source of the date of March 2015, which is entered into the agreement, that is the amended facility agreement that we get in September 2014, that's at the heart of the dispute. But that's how it was put, anyway, by E.C. Harris on the 28th of April. They've still got the budget estimate of 665 million, and that's what they say about the March date and their own view of. So that was the background then to the facilities being, or drawdown under the facilities being restored, and indeed the facility being amended. We can see that happening. If you turn on in this bundle to tab 112, where we have a risk management committee decision of the bank, and the extract is showing the decision made by that committee give an increased facility. You see the 444 million, it was the figure that previously been available. It's to be increased to 669 million. But there's now to be an appointment of E.C. Harris as project monitoring surveyor, the costs to be borne from the loan proceeds, and appointment of a project manager as well. At bank's discretion, the borrower may be allowed to sell the entire hotel or a number of rooms.
So, E.C. Harris had already, in fact, been appointed, had they?
Well, they've been appointed, it looks like, as a one-off, because they've been appointed to do that assessment.
Just to report to the bank on the state of play.
Yes.
As now they were asking that, requiring.
Yes, now requiring.
A term of the loan that E.C. Harris acts as project monitoring surveyor,
Exactly.
reporting to both bank and client.
Well, reporting to the bank, the client was to pay for it out of the loan, out of the financing, but the
So would the client see the reports?
Well, they were in fact sent the reports, or at least sent the reports that they were sent. They questioned whether there was some more, but the ones that they were sent and that it's agreed were sent are in the bundle. Certainly from August, reports in relation to August 2014 onwards were sent. So that's the increase in the facility. There's a facility letter at the next tab, 113, which notifies the decision, effectively, to the claimant. And again refers to the appointments that are to be made.
Yes.
So then those two appointments are made, and if you look at page 115 of the bundle, the appointment of Hill International as project manager, and if you look at 118, there's the appointment of E.C. Harris.
I'm sorry, where are we now? 118.
118.
Yeah.
And it's a letter from E.C. Harris, but recording
Recording their appointment.
yes, ongoing monitoring.
Yeah.
See at the bottom of the page, they were to do a monthly monitoring report covering the full commercial.
So their role was what? They were monitoring the project while E.C. Hill were managing.
Yes, Hill are to come in as project managers as such, in the usual way, to sit above the cost consultants and engineer, to take an overall responsibility for managing the project, obviously subject to the client. Whereas Harris, so Hill are appointed by the client DAS,
Yes.
whereas it's plain from this that Harris are appointed by the bank.
Yes.
Their deliverables, you can see at the bottom of the page, initial review of the project once the new team has put in place normal project controls, including program and commercial parameters, monthly monitoring report, commercial position of the scheme, results of the day-to-day monitoring of the items.
Yeah.
And over the page, there's what they were to review: the program, commercial management, approvals, progress, design management, procurement, recommendation of drawdowns from the bank to the customer based on certified work done and deliverables, site attendance by senior project manager to overview progress and highlight any risk issues. This will be reported on to the bank in a standard form. So that's 22nd of June. They are appointed to do that. Then I think there's one document I should show you before we get to the revised facility. That's a document in Bundle 9, which is a paper produced by Hill, the project manager.
Yeah.
If you go to tab 129, it's Mr. Pjsc of Hill sending through a briefing paper to DAS on the 10th of August, and the paper starts over the page, and see on page 1785, it's a precursor to a discussion on Sunday the 10th of August that's been called by E.C. Harris to address the agenda defined in the meeting notification, extension of time claims and contractor payment programme, amendments of the contract and the development budget. So the project managers produced this for a meeting called by E.C. Harris. And I think what's important to note from this is probably page 1787 and 1790. 1787, they deal with schedule considerations. They say that on the 10th of July, IME, that's Intermas, submitted a revised schedule to completion date of the 1st of March 2015. That's now as compared to the December date that we saw earlier, but with completion stated as excluding testing and commissioning and authority approvals. From previous schedules submitted by IME, the duration of testing and commissioning and authority BCC issue has been submitted as being 4 months. Harris had put it at 3, but anyway, 3 or 4 months. So that would mean we're heading for a development completion date of July. As such, the actual handover completion date proposed by IME in their submission of 10th of July approximates to handover only by the 1st of July 2015. They then refer to the schedule being technically deficient, and IME were advised that their schedule was unacceptable and a resubmission remains pending. And then progress, construction, second paragraph, due to the front-loaded critical schedule issues not being addressed and now alleged to be causing day-for-day delays, the projected completion date was reported as the 29th of March 2015. I'm sorry, I should have read the first 2 lines. There'd been a progress meeting, number 158, and the report then was that the projected completion date is 29th of March. So that's back from the beginning of March to the end of March, since the submission of the programme on the 10th of July. And then the projected handover completion date is consequently currently estimated by Hill International, that is, as being the 1st of August, if the current status is allowed to continue. Labour force on site fluctuates between 200 and 250 a day against a subjectively estimated requirement of 750 to 1,000 a day. So, view of the project manager at this stage, well before the 28th of September, that completion was heading for August, if the current status stayed as it was.
Well, maybe you don't know, but I mean, were Hill's assessment of the projected handover date and assessment of progress on the basis that the labour force would remain as it was, or on the basis that it was going to quadruple?
Well, we know no more than is written in the documents as to that. But we know that's their current estimate.
Yeah.
And what we do know is that even the schedule was pointing to the 1st of July. So even the contractor was scheduling the 1st of July. Maybe look at 1790 briefly, because there's reference there to contract amendments, maybe less significant following the written openings, but I draw attention to it. There were 2 contract amendments that have been issued to the contractor. One of them was to essentially introduce Hill and provide a paragraph to go into the contract to allow for there being a project manager, and then an amendment to reflect a revised contract price. Both of these were said at that stage to be unsigned by the contractor. Third amendment to extend the time allowed for payment had been rejected by the by the contractor. I think that then I don't need to show you any more documents before the date of the amended and restated facility, which was the 28th of September. The Lordship had a chance to look at that agreement and the clauses.
Well, I'm only by, in a sense, the answer not as such. I mean, obviously, I've seen a lot of the terms in the citizen arguments, but I haven't studied the document.
Well, I think it might be helpful just to have a look at it then. It's in Bundle 6.
Yeah.
And it's tab 45. And I'll just show you the structure of the document to start with. There is, you see it's called Amended and Restated Agreement, dated the 28th of September. And it's a relatively short document that goes from 1041 to 1048.
Yes.
And then has schedules, Schedule 1 being conditions precedent, Schedule 2 being conditions subsequent, 1051, and Schedule 3, 1053, being an amended facility agreement as such. And that, I mean, that's an amendment to the original facility agreement, is Schedule 3.
Yes.
I'll indicate the clauses that feature in the dispute between the parties. If I take you back to the beginning of the agreement itself, you can see the structure of it from the recitals. It recites at A that it's pursuant to the original facility agreement, the 2008 facility. It recites the 2010 amendment when the amount was reduced, earlier, to 444 million. Another amendment in 2013, which doesn't really matter. And then there's been an agreement to further amend the facility as defined below. So this agreement is putting into effect the facility that was foreseen and agreed in principle by the facility letter back in May, following the decision made on the 27th of May. Now, there is one clause of this amendment agreement itself, the short agreement, that matters, and that's clause 5.3. Perhaps it's helpful to look at 5.1 again, just structurally. So it's with effect from the restatement date, the original facility agreement shall be amended and restated in the form set out in Schedule 3. And then 5.3, the conditions subsequent matters, will matter for your Lordship's decision, because that's one of the clauses.
Yeah.
One condition subsequent that wasn't fulfilled that entitled termination of the facility. And then Schedule 2 at page 1051 set out the conditions subsequent. Three were relied upon at the time of the termination in May 2015, numbers 1, 2 and 4. It appears that it's now only 2 that's relied upon. And then Schedule 3, the amended facility agreement itself. If I can show you the relevant clauses of that, if I ask you to stop at page 1065 in the definitions, and note Facility A commitments and Facility B commitments. So the 444 million, that was the originally agreed amount under the facility beforehand, which we saw increased to 669 at the decision made by the Risk Management Committee in May, and so now that's defined as the two facilities. And then if you go on to page 1075, there's the facility. Subject to the terms of this agreement, the lender makes available to the borrower those two facilities. Then on in this agreement, we come to 22 on page 1108. Where there's a heading of general undertakings. The undertakings in this clause remain in force from the date of this agreement, or so long as any amount is outstanding under the finance documents. And one of these general undertakings is centre stage in the dispute. It's clause 22.5a at the bottom of the next page, where we see that the date of 1st of March 2015, the date we saw in the Harris report of 28th April 2014, the borrower shall procure development completion that occurs no later than that date. A date which we say by 28th of September was already not achieved. And then, so that clause appears as a general undertaking. If you go on then to clause 23, which begins at 1117, there are events of default. And first and foremost, as one would expect, it's non-payment of amount payable pursuant to a finance document. Then 23.2 is important. It's other obligations, because this is a clause relied upon by the defendant bank. The borrower does not comply with any of its other obligations, worry about the brackets, under the finance documents, and such non-compliance is capable of remedy and is not remedied within 15 business days. The borrower receiving notice of such failure from the lender, requiring the same to be remedied. So it's the bank's case that there was an event of default under clause 23.2 because there was a failure to procure development completion by the 31st of March 2015, whereas the payment says that's not within the clause because that obligation was not capable of remedy, and there was no notice given requiring remedy within 50 days. So that's a central issue between the parties. Other clauses that are relevant, 23.11, if you go on to 1119, material adverse change is an event of default. That was not relied upon by the bank at the time they terminated the facility in May 2015, and was first relied upon as an event of default, first alleged to be an event of default by the amended defence. And I ask you to note the terms of material adverse change, both A and B. And you will note from 2311B that material adverse effect is capitalised and is a defined term, and that definition.
I was just trying to look and find that.
That's at page 1069.
Yeah.
Quite particular, materially impair the ability of the borrower to perform or observe any of its repayment or other material obligations under any finance documents. So 2311B and the definition work together.
Yes.
I think for present purposes there are probably just two other clauses I should refer you to. On page 1122, provision about notices. You will see there was a requirement for notice under clause 23.2. Any communication under or in connection with the finance documents shall be made in writing. And clause 30, finally on page 1123, this is a clause relied upon by the defendant because we say in the alternative if there was a right to terminate originally, then that was waived, then the defendant relies on this no waiver.
Thank you.
I think those are any clauses I need to show you in opening. And then
Governing laws, Abu Dhabi and the UAE.
yes, it is.
Yeah.
I think then we can put away that contracts and look at some of the events that happened after the 28th of September. And what happens very quickly is that we get another E.C. Harris report, which we find in bundle 10. And that's at tab 152. The first page is the covering email from E.C. Harris to the bank with the monthly monitoring report. And it is the report for August, even though it's only coming out on the 9th of October, and they are saying that it's because of the timing of the receipt of the reports. Now this report then, we go to the executive summary at page 2082. Now programme and progress. The contractor's programme has yet to be accepted. Has a completion date of 31st of March 2015. The outstanding design issues are addressed and the nominated fit-out subcontracts issue. Finalisation of the programme will not be possible. That programme showing that date does not include installation of furniture, fixtures and fittings, operating supplies and equipment. The project manager has been requested for a master programme capturing the above. Manpower of the main contractor throughout August fluctuated between 250 to 300, considerably below the project manager's estimated required amount of 850. And then there's paragraphs on procurement and designment, third-party approvals, and then their view at the bottom of the page. Based on the above, it's our assessment that the current reported project completion of 31st of March 2015 is not achievable. And over the page 2083 recommended actions, we can note that they say that the report is based on progress reported during August 2014. They note that there's been a meeting on the 1st of October. The criticality of outstanding issues has been discussed, and they make some further recommendations. So we say that that's descriptive of the position as it was in August, and already by that time in August the assessment was that the date of 31st of March for development completion was not achieved. Then there's an internal report within the bank shortly follows this at tab 153.
Sorry, tab which?
What, 153?
Yeah.
So internally, this was the view of the bank on 12th of October. You can see in the summary the position at the 12th of October, and the amount of the loan is noted and how much is outstanding. And I ask you to note in the box on the right-hand side, the security coverage is 194%. There's the update, but then I ask you to note the key issues. They report that there are disputes between the contractor and the claimant, that resources on site remain insufficient and work is minimal pending resolution of the time claims. Development budget's not finalised. Finalisation of the work programme is pending, addressing the outstanding design issues, nomination of subcontractors, accounting for installation time for furniture, fixtures and fittings and supplies. And they note now a potential slippage of the completion date to August 2015 from March 2015. So as quickly as that, within 2 to 3 weeks of the facility, there's the bank its own internal report noting this potential slippage from March to August. Then the next EC Harris report is on the 23rd of October and is at report for September. Sorry, I said 23rd of October, 26th of October. If you look at tab 158. And how things have. They're now saying on page 2129. First paragraph under programme and progress. Our master programme, it shows installation works finishing on the 30th of June. Harris believes these dates are significantly at risk. They note the manpower of the main contractor throughout September averaged 330, as opposed to the project manager's estimate of 850. Then if we go on to 166 and on to early December, there is an email from EC Harris to the bank with advance notice, in effect, of a summary that they were intending to record in the monthly report, and asking if there were any comments before it was actually included. It seems to get toned down a bit, but Mr. Hall of Paris, his first view of this anyway, under 1.1, was that the main contractor and its MEP subcontractor has become increasingly assertive and aggressive in nature in order to force the employer to accept and pay claimed extension of time amounts. This involves premature removal of site resources and placing procurement on hold until the extension of time is resolved. Both could be deemed breach of contract. In order to attempt to progress the project and mitigate the delays associated with the drawn-out contractual claim determination process, the project team arranged a project principals meeting on 17th of November with both Intermass and the MEP subcontractor, senior management present. At this meeting, JLW verbally advised that it required closure on EOTs prior to committing to close out the project. So that was the draft reference to increasingly assertive conduct. The actual report that came out a few days later is in Bundle 11, which I think we can now go on to. And it's at tab 169. And the executive summary is at page 2286. Now, the project manager's produced an updated master programme showing a completion date of 3rd of September 2015. Paris believes this date to be at risk, and timely conclusion of the EOTs. Outstanding design issues must be achieved in order to make this completion date realistic. And construction progress on site remains limited. Main contractor is currently delaying expenditure on procurement of long lead MEP items due to a strategy to attempt to conclude the claims. This is in breach of contract, and whilst the engineer must continue to issue relevant notifications regarding this, the project team has currently investigated opportunities for all parties to agree the EOT and progress the remaining works. So a little bit toned down from the first draft, but still describing an unhappy position. There were negotiations at this time between the employer and the contractor, and you can see a little of those at tab 171 in this bundle. If you look at first at page 2318.1, a letter from DAS, the claimant, of the 16th of December, in which they made an offer to settle the contractor's claims. You can see that they refer to a letter of the 23rd of November, which we don't have in our bundle, in which there had essentially been a proposal from the contractor, and here was the counter-offer from DAS. Paragraph was made with a view to resolving the contractor's claims. The first and final offer on which it will be negotiating. As you can see, then the proposal set out, and it involved payment of an amount of 36 million. The detail of that and rights and wrongs of that are not something that concerns you in any detail. It's just the fact of that happening. And then if you go then back in the bundle to 2317, you can see that those events are before the bank, because Mr. Hall of Paris reports on that to the bank. They've reviewed what's been going on, and they make those points to the bank. And just at the end of the email, the last 4 lines, they say if the main contractor rejects the counteroffer, the claims will follow the engineer's determination process, and the contractor must immediately confirm that all works are progressing. So that's state of play in December. Now at that point, or shortly thereafter it, an issue comes into the open about the contractor's license, and this happens in the middle of December, and tab 175 has the documents where this blows up. And if you go to the back of the tab to start with, the last document is an email from Trackies, which is the authority on the Palm where the project is. It's the regulatory authority on the Palm, and it's to the engineer on the project, Arif and Bintok, saying that the contractor's trade license has a remark of not permitting to do any contracts until resolving technical staff.
I'm not looking in the right place.
Oh,
What page are you on?
I'm on page, it actually doesn't have a page number, it's the last page in tab 175.
My last page is 2331.
Oh, Lordship has an advantage over me. Has it got an AB in the top left-hand corner, and underneath that from Wael Mohammed?
Yes.
That's what I'm referring to.
Oh, right. With the additional seafood restaurant.
Yes.
Yeah. So I see. I'm now seeing it. So I apologise. I didn't see it.
So it's Trackies saying that they're turning down an application to carry out the works to the additional seafood restaurant at the hotel. And if you work backwards in the bundle, you can see that this gets referred to the contractor. At the bottom.
I'm not sure I'm understanding page 2331.
It's
the contractor's trade licence has a remark of not permitting to do any contracts until resolving the technical staff issue. Now, what was the technical staff issue?
Well, it appears to be an issue of not having a labour camp in Dubai, and I'll try to explain this. Frankly, it was not terribly clear from the documents, and we've endeavoured to get...
This comes from Trackies, and Trackies are what?
Trackies are the planning authority on the Palm.
Okay.
They're responsible for all approvals on the Palm.
Right, sorry, we go backwards.
Yes, we go backwards. It gets referred to the contractor,
right,
essentially, of what's all this about, and that's the bottom of the page. Top of the page it's chased, and then it's chased again on the 30th of December. You can skip over 2328 and go back to 2327 where it's chased again. It's not an entirely clear story. Well, far from that. Let me try to help. Mr. Al-Mahiri gives some material about this in his witness statement, which I think it might be helpful for you just to have a look at now. If you look at bundle 2, tab 13, and go to page 253 of the bundle.
Yeah.
He shed some light on it, and then I'll endeavour to shed some more light on it by showing you relevant regulations. So I think if you read 67 to 70.
I'm just halfway through 68. Okay.
And then if I ask you to read 75 over the page.
Okay.
I think that's enough of that for now. Then I should show you another document in bundle 11 where trackees.
Waving?
Go back to bundle 11.
Oh, sorry,
please.
yeah.
Yeah, we saw the issue blow up, as it were, in the second half of December 2014. Trackees gave some explanation in a letter at page tab 192 of bundle 11 in response to an inquiry from Mr. Al-Maheri, and they inform him that the mark on the trade license.
So what appears in the email is actually what was written on the licenses.
Yes, that's right. Yes.
Thank you.
I can show you the license if
No, don't worry. I've
the license is in the
Thank you
bundle.
very much. Yeah.
So that's the translation of, and I should say this is an agreed translation, this one. 9 words are what's on the license, and they say that it was added in October 2013, effective, and it concerns the issuance of permits for additional construction works for the project. Transactions being rejected. The application made on the 15th of December being rejected because of this restriction.
Yeah. There's no identity of quotes the requisite criteria that are not being fulfilled.
They're not, but that's what I'll try and help with that.
You do say, as I understand, or your client says, that it may well be they were busing their personnel in from Sharjah, which was not a permitted process under the...
That's right.
Yeah.
And can I just show you some of the regulatory background, which is in our authorities bundle, the claimants authorities bundle, which does just show you, I think, how it fits into the regulation. You should have a bundle labelled claimants authorities.
Yes.
And if you go to the back of this at tab 16,
Yes.
you find, as it were, starting at the beginning, this is a Dubai law on the regulation and practice of economic activities in the Emirate.
Yeah.
And if you go to page 282 of this and Article 6, you'll see that the the law is that you're not allowed to carry out any economic activity in Dubai unless you've got a permit to do so. That has to be granted by the said department, and the said department is the Department of Economic Development, which definitions on page 281. So if a company wants to operate in Dubai, it's got to have a license. Then if you go to tab 18 in this bundle,
I mean, what seems to be stamped on the license is simply a repetition of the obligation to abide by the restrictions. No more, no less.
That's right. Yes, but
That's not surprising.
well, it's not it's not surprising, but the evidence effectively is that there's a non-compliance.
Some non-compliance, right. We're now on
because the
provided
permission
18.
turned down. 18 and 19 really go together. Now this is showing this is now the government of Dubai, and this is showing this is dealing with registration at 18 on a temporary basis and then at 19 on a permanent basis. So you get a temporary registration in Dubai after obtaining, sorry, I should say this is the building department do this.
Yeah.
And this covers the consultants and contractors, and it enables them to get a registration on a temporary basis after getting initial approval from the Department of Economic Development, that allows them to set up and get an office and phone and employ staff and so on. And then I think then if you go to 19, you can see the permanent basis. This service name is the request to activate or renew a contractor's license. Then consultants and contractors qualification. The service enables the customer to begin practicing the activity, license activation, or obtain a renewal of the commercial license for all contracting companies where this service is mandatory and eligible by contractors working in Dubai. So this is what contractors, they have to get this registration, and over the page you can see the documents that are required for them to get it, and this shows documents required, and you'll note that one of those is a copy of labour camp tenancy contract. So that appears to have been piecing the evidence together what the problem was. They were applications for new work were being turned down, or that application for the new seafood restaurant was turned down because of that problem. The last regulation in the bundle is Pjsc's Civil Engineering Division procedure for building permits. So this is tab 21. 1.0, the purpose is to outline the procedure for the client to obtain a building permit for their specific project. The building permit obtained will enable them to initiate the construction on site. And then at the bottom of the page, there are 4 types of building permit submissions that applied for through the help desk: a new building permit or a revised building permit. Any type of modification, minor or major, that occurs during the construction period within the validity of the building permit, classified as a revision. So it appears that if you want to make any revision to your works that are permitted by the initial permit, then you've got to get a revision. And because the fish restaurant, the seafood restaurant, was additional work, it appears that was being turned down because of the problem about the labour camp not being in Dubai. There's a recent document come into the bundle, in fact, yesterday.
On page 318, the list of documents needed to be submitted. don't include the Labour camp tenancy, do they? Can't see it.
No, it's not in that.
I mean, I don't know what that list is, but it's not there for what it's worth.
No, it's not. I'll have to find out a little more about that list.
I need some legal help on this. Okay. Thank you. Right, you're going now where?
I was going now to a document that came out yesterday from the defendant, and it's gone into the bundle at bundle 13, page 229A.
Yeah.
It's an email from Mr. Schumacher, who was the in charge of Intermass. I've forgotten for the moment whether he's the owner or the chief executive, but he runs Intermass. And this is an email to the bank. On the face of it, copied to Mr. Mahari, but he'll tell your lordship that he didn't actually see this. And it says that the employer had the engineer approach trackies for a new building, and they didn't know that. Please find attached copies of building permits obtained from...
Now, the employer for this purpose is...
That's the claimant.
Yeah?
So it is a new, I mean, he's saying also it was a new building, this seafood restaurant. When permission was, so this is the restaurant that was turned down. But he's saying, please find attached copies of building permits obtained from Dubai municipality under Intermass name, which proves that Intermass has a valid Dubai license. Well, now, of course, Dubai municipality is different from Trackies, which is the authority on the palm. For present purposes, though, what I'd like to show you is the second document that was produced, which is at page 2769.4. Which is a translation of a Dubai municipality new building permit issued on the 18th of February, and on the face of it is a permit to in respect of a new Labour residence. You can see that the owner of the site is the government of Dubai Real Estate Corporation. The lessees are Sheikh Sultan Sakia Salem Al Kamzi, Intermass Engineering and Contracting LLC. And the permit is for ground plus 3 plus, I think there must be a roof. Outside service and labour residence. So we only saw this yesterday, but it looks like Intermass were getting permission to build their labour camp in February 2015.
That's February, is it, not April?
Well, it looks like the document was printed in April, but the issue date...
But it's an American nomenclature, is it? Oh, sorry, I'm looking at the permit number. I'm sorry, I'm looking at the wrong place. I do apologise. Yeah, print date is April. Issue date, February, quite right. Yeah.
It's English notation, I think, throughout the documentation, usually. So, I mean, one of the points we make as well, if Intermass are only getting permission to build their labour camp in the middle of February, it's plainly not going to be built to enable the works to be completed by them in respect of anything that yet needs an approval, like March. Done. That, I hope that sheds a little bit of light on documents that are at first somewhat mystifying. So that's...
Thank you.
that's the introduction to the license issue. Going back to the chronology, which we've sort of broke off at the end of December in Bundle 11, if I can just go back to Bundle 11. And show you page 100, I keep saying page, I'm sorry, tab 176. Just to show you what's also happening at this stage, this is the last day of the year, 2014, and there's correspondence going on between Ms. Schocker of the bank and Mr. Sebastian of the claimant, and they're dealing with the conditions subsequent still. You'll have seen that the three conditions subsequent that were relied on at the time of termination were all due on the 30th of September. But here we can certainly see that at the end of the year there's correspondence still going in relation to this provision of these conditions subsequent. And it's notable that what's happening here is that execution versions of the documents are being provided by the bank to DAS for execution. And then the next E.C. Harris report is in this bundle at tab 182. This is their report for December 2014, which you can see on page 2351. And if I show you the paragraph 1.1, now the position is there's been an updated master programme showing an anticipated project completion date of 29th September 2015, which is a slip of 1 month from the November status. There's a significant risk that will continue to slip due to ongoing limited procurement and progress from the main contractor, ongoing EOT issues and variations, and continued lack of closeout of identified design issues. Limited progress has been made throughout December, and at the end of that paragraph, the main contractor is continuing to delay expenditure on the procurement of long lead MEP items. This is in breach of contract, and the engineer such notifications. And over the page at 2356, they refer to the negotiations that had happened between DAS and the contractor. They refer to that offer that we saw made on the 16th of December for the prolongation period from 15th of November 2012 to 30th of September 2015. So that was the offer. The main contractor subsequently rejected the counter-offer. The project team has confirmed the contractual process will continue to be followed towards arbitration. Should the lack of progress and outstanding MEP procurement continue from the main contractor, there's a strong possibility that the owner may consider termination. So that possibility now comes onto the agenda. That was the December report that was produced in January 2015 for December 2014. At around this time, at the end of January, there was a valuation of the project in an as completed state, which you can see at tab 183 of this bundle. It's a CBRE valuation of 29th of January. And you can see the valuation. I think you just need to note the figure on page 2395. The day one market value is 1.28 billion. Stabilised, they thought that would rise to 1.45 billion.
This is a completion value.
As at completion, yes. So that first figure is what they call a day one market value. And I don't think it's controversial. I mean, if you read on, it's what they mean is the day you get the thing opened, and then stabilisations once it's settled down into being an ongoing business, value rises. On the same day, at 184, tab 184, the engineer under the project issues a certificate under clause 63 of the building contract, effectively that the employer, the claimant, is entitled to terminate. Complaints they there set out.
Repudiatory breach, was this in the form of delay or
yes, it's
anticipatory breach?
It's delay, and it's the conduct in deliberately holding back procurement. And despite the warnings they see. So consequently, the paragraph across the page, the employer may, after giving 14 days notice, decide and terminate the employment of the contractor. That's refuted, of course, by Intermas at page 2450. And that potential for termination of Intermas's contract really seems to be at the beginning of different approaches from the bank and from the claimant. We've seen up to this point, whilst there have been considerable delays, and the March date plainly going to be missed by a very long way, there are not letters or statements or notices from the bank saying, oh, this is right to terminate here because of your delays. But when the prospect of a termination of Intermas's contract appears, then it seems that the approach of the parties does begin to diverge. And I think we potentially first see that in a document of the 5th of February at tab 187 of this bundle. Which is a bank internal document giving an update. I think if I take you to the bottom of the page and the last two bullets there, you can see that they've had meetings over the last 3 months. And at the bottom they note the certificate. Then strategy and action plan. We explain to the client that the bank does not recommend termination of Intermas and that this will lead to stopping our finance. He seems to be moving towards termination of Intermas and Hill. This, along with the reports that he met with Knight Frank last week, lead to the conclusion that he's probably heading also to sell the project. We'll meet with the client this week to stress the bank's stance against termination of the main contractor and project manager, given the advanced stage of the project, and to get some visibility on the potential sale. And that indeed does seem that the bank's stance was against termination of Intermas, whereas the claimant wanted to.
Yes, I think we must give the shorthand round.
Yes.
Thank you very much.
All rise.